This module will discuss civil, tort, and criminal actions that could have an impact on EMS providers. Once completed with this module, you should be able to describe some basic legal concepts regarding the United States legal system, describe specific crimes and their associated elements as related to EMS, and describe the elements of negligence, possible defenses to a negligence claim, and potential limitations to civil liability. This module addresses principles of civil, tort, and criminal law as applied to EMS agencies and providers. In providing this information, nothing in this presentation should be construed as legal advice. Rather, the information provided is merely a broad overview of this legal subject as denoted within the National Paramedic Educational Standards. Please be aware that every state has different laws that impact EMS agencies and providers, and these laws may change over time by application of legislative action or court decisions. Federal, state, and local laws and other legal provisions not discussed within this presentation may also impact EMS agencies and providers. Additionally, information that was current or applicable at the time this presentation was produced may not be at the time you are watching this presentation, and new laws may have been added as well. Lastly, the legal topics and doctrines discussed within these presentations are not the totality of all laws that apply to EMS agencies and providers. There are numerous other laws and provisions that impact diverse aspects of providing EMS. If you or any other EMS provider has questions related to the laws that apply within the realm of providing EMS, additional guidance and assistance should be obtained from a licensed attorney within your area who has subject matter expertise in the specific area of law in question. To assist in your understanding of civil torts and criminal laws as they apply to EMS agencies and providers, it will be helpful to explore some basic concepts related to our legal system within the United States. When our country was in its infancy, we brought vestiges of the British legal system over with us. Namely, laws were not written, rather we used what was known as English common law. This law was developed over time through the application of legal decisions by magistrates who tried to apply the wishes of the king. Obviously, this type of law can be very nebulous as one magistrate could rule very differently from another, and there is the very real possibility that an average common citizen may not even be aware of legal provisions and requirements that could be held against him or her. When the United States system of government was created by virtue of the drafting and ratification of the United States Constitution, our founding fathers developed something that was unique and unheard of at the time. Rather than all governmental power and authority originating with a single ruler such as a king, our founding fathers believed that a government derives its power and authority directly from the people it governs. The people agree to be governed and, therefore, imbue part of their authority as individuals with inherent rights to the government under which they live. Thus, as far as our system of government and laws is concerned, the United States Constitution is a supreme law of the land. All subsequent laws at all levels of government must comply with the provisions of the Constitution. If they do not, such laws will be invalidated as unconstitutional. Individual states also have their own constitutions, which not only define the laws within those states, but they must also comply with the provisions defined within the U.S. Constitution. As this is not a social studies course, we will not delve much deeper into our system of government, our three branches of government, the checks and balances that are in place, and so on. Rather, let's direct our efforts in evaluating how laws are generated that ultimately impact EMS. At both the federal and state level, legislative bodies exist that actually write laws. These bodies can even exist at lower levels, although local municipal laws are often referred to as ordinances or resolutions as opposed to state statutes or federal code. Because legislators are not subject matter experts, it is not uncommon for them to create administrative bodies to oversee the implementation of various laws. These regulatory bodies subsequently create administrative rules that are also added to the body of laws that applies to the subject matter over which the regulatory body has authority. Within Wisconsin, State Statute 256 defines emergency medicine and relegates administrative authority over EMS agencies and providers to the state's Department of Health Services, which subsequently created the regulation DHS 110, which defines various nuances related to EMS agency and provider licensing and functioning. As far as our judicial system is concerned, if there is a dispute as to a legal right, civilly, between two parties, or the violation of a law, a crime, those grievances and disputes are heard by the courts. What particular court hears the case depends upon the subject matter in dispute and the geographical location of the case. There is both a system of courts at the federal level as well as the state level. Regardless of which system, federal or state, is hearing the case, there is a court of original jurisdiction in which the case is first started. While the name of the court may vary based upon the state or the particular subject matter of the federal court, the legal action must begin somewhere. These courts of original jurisdiction are where all lawsuits and criminal proceedings begin. Ultimately, once a case is decided by the court, one of the parties may believe there was a miscarriage of justice and that the law, as it applies to the particular case, was not applied correctly by the court. If that is the case, the wrong party does have the ability to appeal the decision to a higher appeals court. Each state, as well as the federal judicial system, also has a court of last resort, commonly referred to as a Supreme Court, although the name can differ based upon the state. Once a case is heard by such a court, or such a court refuses to hear the case, that exhausts all opportunities to appeal the case, and the decision by the appeals court is final. To introduce a certain amount of predictability within the judicial system, our courts also follow what is known as the doctrine of stare decisis. This means that the decisions of higher courts establish legal precedent that must be followed by lower courts within the same system. Needless to say, questions as to jurisdiction and the application of binding legal precedent on a particular case can be a very complicated matter. Seeking assistance from an attorney in navigating these waters can be extraordinarily beneficial for a party to a lawsuit or a criminal defendant. For a moment, we will focus solely on civil lawsuits. As opposed to a crime where a party breaks the law and thus wrongs society as a whole, a civil case arises when a party or entity wrongs another party or entity. In the Old West, disputes of this nature may have been handled by a showdown at high noon. Now, however, our system of laws requires such disputes to be resolved within courts of law. For a civil lawsuit to be started, there must first be some type of actionable cause. Essentially, one party or entity must wrong another party or entity in such a fashion that the law recognizes a breach in the social contract that has been historically maintained at common law between all members of civilized society. An easy example is a car accident where one person was not paying attention and hit another person, causing damages. A resulting legal action in such a case would be one related to negligence on the part of the driver. On the flip side, it is also important to recognize that there can be conduct between parties that, while one party does not like it, does not give rise to an actionable civil cause of action. An example would be where someone says something to another that hurts the individual's feelings. The individual may not like it, but hurt feelings does not give rise to a civil lawsuit. Another example would be a business entity that competitively bids against others and wins a lucrative contract to provide goods or perform services. While all is not always fair in love and war, sometimes there is a winner and a loser in business dealings, and absent a law that defines when certain business conduct is illegal, competition and market forces are routine realities that must be addressed by businesses. If a party believes that he, she, or it has been civilly wronged by another, the first step in the process of a civil lawsuit is to file a complaint with the court. Essentially, this is a process whereby the plaintiff, the one who starts the lawsuit, initiates the process, files appropriate paperwork with the court, pays required fees, and places the defendants on notice that they are being sued in court. The defendant or defendants then have a specific period of time in which to respond to the complaint and refute the plaintiff's claim. Assuming the case has merit and survives motions to dismiss, the next step in the civil lawsuit is the discovery phase, in which the parties have an opportunity to investigate the available evidence related to the claim. Aside from pieces of physical evidence, such as pictures of the cars involved in the accident or emergency response agency reports like the police accident report or an EMS patient care report, witnesses are often asked to provide information related to the event in question that gave rise to the civil wrong alleged in the lawsuit. Two very popular methods of discovery for witness testimony are depositions and interrogatories. In a deposition, attorneys have the opportunity to ask the witness questions about the incident involved in the case. Rather than occurring in a court during trial, however, the deposition often is held in a meeting space, such as an office or a conference room space. There is no judge present. Rather, a court reporter records a verbatim record of every question and response. Each side has the opportunity to ask questions of the witness who is under oath at the time. If there is a dispute as to a particular question or response, objections may still be lodged, and the presiding officer, typically a judge, can make a determination at a later time whether or not the question or response should remain or be stricken from the record. Sometimes depositions may even be video recorded for possible showing at trial. An interrogatory is a document whereby the witness is asked a series of questions and responds honestly to those questions in writing. Throughout the process of discovery, it is not unusual for parties to position and posture for legal advantage based upon the available evidence and what it shows. It is often within the discovery phase where the parties may be the most motivated to reach an amicable settlement to end the lawsuit without going to trial. If the parties cannot reach such a settlement, however, there is a point in time where the case is eventually heard by a trial court. Depending upon the court and the subject matter, the case may be heard by a jury, or the case may warrant only a bench trial, meaning there is no jury and the judge becomes the arbiter of both law and fact. Parties may still elect to settle at some point during a trial, but that is not as common as it is during the discovery phase of the lawsuit. Unlike what you may have seen on television, all parties have access to all evidence before trial, and the Perry Mason smoking gun presentation that wows the jury and guarantees a win for that particular party is an extraordinarily rare occurrence indeed. Once all parties have presented their evidence and arguments, a decision is made by the court, and the settlement, the payment of money for damages suffered by the plaintiff, is recorded. As mentioned in the previous slide, if the losing party to a civil lawsuit believes the judge applied the law incorrectly to the case, that party may attempt to appeal the decision. Despite what some believe, simply losing a lawsuit does not mean you are entitled to an appeal. Essentially, only errors of law may be appealed. Findings of fact, which fall within the purview of the jury or the judge in a bench trial, may not be appealed. If the jury believes the light was red before the defendant entered the intersection and hit the plaintiff, that decision is final and cannot be appealed. If the judge did not allow a piece of evidence that could have established that the light was indeed green for the defendant, however, that could be a case where an error of law occurred and an appeal could potentially result. Once a settlement is reached by the parties or the case is decided by the court and any appeals are exhausted, the case is considered closed and the plaintiff is barred from bringing the same lawsuit again at a later date. While this particular process governs civil wrongs, the process for criminal trials is not horribly different aside from some additional steps on the front end as the criminal defendant enters the criminal justice system through arrest, processing, and arraignment. Within the realm of EMS, there are some civil wrongs that could occur with more frequency than others. Additionally, some of these civil wrongs are routinely considered to be crimes as well. These include various breaches in civil conduct to include assault, battery, false imprisonment, and kidnapping. An assault occurs when one person places another in reasonable fear or apprehension of a harmful or offensive touching. Battery is an actual harmful or offensive touching, which could include providing medical care without the patient's consent. False imprisonment occurs when a party is confined to a particular space against his or her will. Keeping a patient in the back of an ambulance when the patient has full capacity to make healthcare decisions for him or herself and does not want to be there could give rise to both the tort and crime of false imprisonment. Kidnapping is simply false imprisonment that involves moving the person. Keep the person in the back of the ambulance against his or her will and move the ambulance, and a kidnapping could have occurred. An additional civil wrong that could occur within the realm of EMS is defamation, whereby an EMS provider publishes statements or other information that damages the reputation of another. Such defamation can occur in two ways, either orally or in a written format. Slander is oral defamation, libel is written defamation. Because the written word is more permanent, given that it is affixed to some type of physical medium, libel is considered worse than slander. Where we have seen libel become an increasing problem is in social media. Send out a tweet or post something to Facebook about a patient, and not only can you have issues with HIPAA and other patient confidentiality laws, but the patient may be able to sustain a defamation lawsuit against the provider personally. Given our discussion about defamation, it is also important to recognize that many states have laws that require EMS providers to report certain conduct or suspicions to proper authorities. The first such category involves abuse, assault, and neglect. If an EMS provider suspects in good faith that a child is being abused or neglected, the law often requires that EMS provider to notify the police or other appropriate government agency about the suspected abuse or neglect. The same is often true for elder abuse and neglect as well, which, unfortunately, often involves financial and emotional aspects of abuse. Some states also include suspected domestic violence within mandatory reporting laws. Because these laws require EMS providers to report their suspicions, the laws often provide protection against civil lawsuits for those who report in good faith. Some states require the reporting of certain criminal conduct as well, such as sexual assault or certain types of penetrating trauma often associated with a crime, such as a gunshot wound or a stab wound. Given the public health aspect of EMS, certain communicable diseases may need to be reported, along with other healthcare-related incidents, such as an animal bite. Again, these laws vary considerably between states. As mentioned previously, mandatory reporting laws typically provide immunity from civil liability and possibly criminal action for those who report in good faith. As far as civil liability in EMS is concerned, the most prevalent type of tort action is based upon the legal theory of negligence. Within our society, there is an underlying requirement or expectation that people behave reasonably toward others. When a failure to behave reasonably results in someone being harmed, that could give rise to a negligence lawsuit. To sustain a negligence case, the plaintiff, the harmed party that initiates the lawsuit, must prove the existence of 4 elements: duty to act, breach of duty, causation, and damages. To establish a duty to act, the plaintiff must show that the defendant somehow owed him or her a duty to act reasonably. This duty could be established by contract, either a social contract that applies to everyone as members of society as a whole, or by a formalized contract between the parties, or by a duty that was already undertaken by the defendant, whereby the plaintiff had a reasonable expectation that the defendant would continue to behave in a certain way to the plaintiff's benefit. This is one of the key elements to abandonment in EMS. Once care is started, it must continue until another party with the same or higher level of training, knowledge, experience, and credentialing takes over, or the patient knowingly consents to the discontinuation of care. Establishing duty is not always automatic, and there have been plenty of cases whereby the court found no duty was owed to the plaintiff by the defendant. Assuming a duty is established, however, the plaintiff must then show that duty was breached by the defendant. Within the realm of providing medical care, including EMS, this is where the standard of care comes into play, as the standard of care defines how the healthcare provider should treat the patient. A breach can occur through the commission of an overt action, such as intentionally performing a wrong or unlawful act, malfeasance, or performing a right act incorrectly, misfeasance. It can also occur through the lack of action entirely, known as nonfeasance, or an omission to act where there was a duty to act. If the breach resulted in death of the patient, that breach could very well give rise to a wrongful death claim on the part of the patient's survivors. Abandonment can also come into play if the EMS providers discontinue care despite the patient's desire or needs in violation of the standard of care or applicable protocols. There is a legal doctrine within the tort of negligence that may help the plaintiff establish that a breach occurred. Res ipsa loquitur can sometimes be used to establish a breach of duty where ample evidence of the breach is not available, yet it is commonly understood that the harm suffered by the plaintiff could not have occurred absent a breach of duty. If an EMS provider makes a mistake in providing care to an unconscious patient and that provider is alone in the back of the ambulance with the patient, the proof or evidence of that error could be very difficult for the plaintiff to obtain. If the harm suffered by the plaintiff is not really possible without some type of breach of duty on the part of the healthcare provider, res ipsa loquitur may be used by the plaintiff to help establish this particular element within a negligence claim. A breach of duty may also be established by illegal conduct if a law was broken. Take a case where an ambulance driving in a non-emergency mode goes through a red light and causes an accident. Breaking the law, driving through a red light, is evidence of the breach. The third element to negligence is that the breach of duty must be the cause of the harm suffered by the plaintiff. This requires that the breach of duty is sufficiently adequate and applicable in time and space to the plaintiff's harm that responsibility for the harm can be assigned to the defendant's actions. Lastly, the plaintiff must also show that his or her harm results in actual damages, such as physical harm, psychological harm, or financial harm. In cases where the negligence is egregious, courts may also assign punitive damages, which are designed to hit the defendant in the proverbial pocketbook to dissuade similar future actions on the part of the defendant or others. While it may sound from the presentation at this point that civil lawsuits are incredibly common and easy to win, that is not the case, as there are numerous ways that potential defendants, especially those within the realm of providing EMS, may be able to successfully defend against a civil tort claim. As many EMS agencies are actually operated by the government, and many states often limit civil recoveries against governmental entities, governmental immunity may apply. In such cases, the plaintiff may have a very valid lawsuit, but the law prevents him or her from sustaining the cause of action because the government is the defendant. Even if the lawsuit is permitted, some states have civil liability caps that prevent monetary recovery beyond a certain dollar amount, which can often have the effect of limiting lawsuits against government entities, as there is not enough money available under the caps to make the lawsuit financially worthwhile to pursue. Depending upon the underlying claim, there may be a law that provides immunity against civil liability. As already discussed, a law that provides immunity for reporting suspected child abuse is one such example. The law also recognizes that people should not have to look over their shoulder for the rest of their lives given a civil wrong that occurred years earlier. As time goes on, evidence becomes tainted or is destroyed, and people's memories fade. To require someone to defend against a civil lawsuit after a considerable period of time has elapsed from the occurrence of the harmful act is considered unfair for these reasons. Thus, states typically have statutory limitations that define the period of time in which a lawsuit must be filed to attempt to recover for a civil wrong. If the timeline defined in the statute has expired, the lawsuit cannot be initiated. In lawsuits that involve negligence, courts also recognize that the plaintiff can sometimes be partially responsible for his or her own injuries. This doctrine is referred to as either contributory or comparative negligence. Comparative negligence is the most common type of mitigating defense where the plaintiff's eventual recovery is reduced by the percentage he or she contributed to his or her own injuries. In some jurisdictions, if that amount is greater than 50%, meaning the plaintiff is more responsible for his or her own injuries than the defendant, any recovery against the defendant is completely barred. Contributory negligence is a little different in that if the plaintiff is even partially responsible for his or her own injuries, he or she cannot recover against the defendant. As this result is recognized as rather harsh, most states have moved away from contributory negligence and use some form of comparative negligence. Within the realm of providing emergency medical care, many states also have laws that encourage people to help others in need by providing immunity against civil lawsuits when functioning as a proverbial Good Samaritan. Such Good Samaritan laws typically apply only to those who are truly volunteers or are not being compensated for providing such rescue services. Will Good Samaritan statutes protect volunteer EMS providers? That would depend upon how the law was drafted and the facts of the case. Aside from legal defenses to civil liability, EMS providers are encouraged to be proactive to prevent lawsuits from being filed in the first place. This means always acting with professionalism and competence, adhering to protocols and standards of care, doing your job right and doing it well, and providing great customer service and outstanding care for your patients. Try to deliver the same level of care you would expect for yourself or a loved one. Ultimately, if you keep those principles in mind and practice EMS as a professional, regardless of whether you are volunteer, full-time paid, or somewhere in between, your odds of being involved in a lawsuit will be minimized significantly. Beyond those proactive steps, EMS agencies and providers may also find it beneficial to carry liability or medical malpractice insurance. Not only will the insurance help pay a successful tort claim against you, but the insurance company will also provide legal counsel to help defend against the lawsuit. As hourly rates for legal representation can be rather high, this benefit can be invaluable if you are ever involved in a lawsuit within your professional capacity as an EMS provider. Believe it or not, this presentation just barely scratched the surface of the topics we just discussed. If you are interested in learning more, you are encouraged to pursue other training or education or seek other resources that contain additional information. For the time being, however, you should now be able to describe basic legal concepts regarding the United States legal system, describe specific crimes and their associated elements as related to EMS, and describe the elements of negligence, possible defenses to a civil claim, and potential limitations to civil liability. This presentation was prepared by Waukesha County Technical College in Pewaukee, Wisconsin, and is distributed with an Attribution Non-Commercial Share-alike 4.0 International Creative Commons license. Copyright 2019 Waukesha County Technical College. For information on WCTC's numerous fire and EMS educational offerings, please visit us online at wctc.edu.